I hope you didn't do that to Mr. Hamlin.
It was discussed, not acted upon.
Considered.
Yes, sir.
Yes, sir. Come on up.
Good morning, judges. Randy Chisholm from the Obion County Bar, and as Judge Stafford indicated, this is the second time we've been here on this case. Your Honors, of course, this is a parental termination and a step-parent adoption case, and we've been here on appeal before where this court reversed the trial court in finding neither of the grounds for termination were willful. Not willful failure to support, not willful abandonment by visitation. Of course, the Supreme Court has sent it back and instructed the trial court to consider the best interest test. The Supreme Court did find that there was one ground of termination, therefore failure to support. So the focus of my brief, Your Honors, was simply to go through the trial courts.
Have I asked you about rebuttal time?
I'm sorry.
Rebuttal time?
Oh, I'm sorry, Your Honor. I've been here for too long. 5 minutes, if you might.
5 minutes, all right.
And thank you, Your Honor. Our position is there are three factors that really make the best interest test difficult in this case. First was the denied visitation. Your Honor, there are 20 factors in the best interest test listed by statute, plus a catch-all, anything else that should be relevant. And Your Honor, the denied visitation, by my analysis, affects about 12 of those 20 factors. It makes it when the father did not have visitation with the child, especially with a child of this age, he was limited in what he could do by the time we got to trial. For example, my client was living with the child for the first 12 months of his life. He had limited visitation for the next 5 months, so 17 months total. By the time of trial, this child was slightly over 3 years old, I think maybe 39 months, and he had seen the child for 17 months, and the stepfather had been with the child for the rest of that time, not just 19 or 20 months more, but at a time when the child is progressing in age. So that in and of itself skewed the best interest analysis in the favor of, of termination and in favor of the relationship with the stepfather. I don't think any of us, after seeing children and grandchildren, would expect the bonding of a 17-month-old to be the same as the bonding of a 36 or 37-month-old child. They progress, they attach, they learn more. Everything changes at that point. And that factor, that denied visitation, affects, as I said, 12 of those 20 factors.
But let me ask you this. In making your argument assumes that the father would have taken actions in order for that argument to fly, basically. I mean, you're saying that if I'm understanding what you're putting forth, you're saying that he was denied the opportunity to interact with the child. And if he had not been denied that opportunity, he would have a relationship, or he would have all of the things that, it's I guess what I'm saying, it's easy to go back and say, well, he would have done this and he would have done that if he could have, but he couldn't, so therefore it shouldn't matter. Well,
Your Honor, I think that the fact that he had hired Mr. Powell, as you know, and Mr. Powell died 6 months unexpectedly after accepting the case and after being paid a large retainer, he had already hired an attorney. He was trying to establish parentage, have a visitation schedule.
Wasn't he ordered to take a drug test?
He was, Your Honor.
And how long did he wait?
He waited 5 months, and that was obviously a mistake. At that point, he was unrepresented. He had no counsel. He testified at trial that he was afraid if he failed the drug test, he would lose his child. If he had had an attorney, Mr. Powell was still alive, I would assert that he's told, go take the drug test. If you fail it, the court is likely to give you supervised visitation. You'll be seeing your child. and then you'll be smarter, and you'll quit doing that, and you'll pass the drug test and be a responsible parent. And
Again, presuming what the father would have done.
correct, Your Honor. But we would assert that hiring the attorney and going through that process and filing the petition, he even testified that he called child support, and that was unrefuted, and child support wouldn't set the child support payments because he had a pending case, which is normal process.
So how did this visitation, I'm a little confused. I've slept since we've been through this.
Since 2023?
True. He hired Mr. Powell. Mr. Powell passed away.
Yes.
How did the visitation issue get to court then? Did he file a pro se petition, or how did that come into being?
No, actually, Mr. Hamblin's client, the mother and the stepfather, filed a motion for a drug test.
Because of?
Suspected drug usage.
Well, I understand, but there was no visitation going on.
There was no visitation going on, Your Honor, and I was not there. I actually, I think, sitting from that chair, Judge Armstrong asked the same question last time when these videos not only help the litigants, but I can go back and watch the argument as well. Asked the same question, and there was never, really an answer. He was, because he wasn't requesting visitation at that point, I really think he was sitting there doing nothing. He testified at trial that, he had been to talk to Mr. Powell's firm. Mr. Powell at that point, it's very complicated, had gone to another firm and associated with them, and they, the money was gone. They didn't take it on a pro bono basis, and he had no other money.
Was this and it really doesn't matter, but I'm just curious, was this something in juvenile court at the time, or was it always in Chancery Court?
No, Your Honor, it was in Chancery Court the entire time. We've, with serious custody issues, we've had a history of sometimes skipping juvenile court and going straight to Chancery, and Chancellor Malone allows that. And there was no dependency and neglect issue at that point. It was just custody.
Okay.
The second factor that we think causes a problem with the best interest analysis is the separation of the parties that was addressed in the Rule 60 motion, the separation of mother and stepfather.
And I don't know if you want to address Mr. Hamlin's motion at this juncture or not.
Well, Your Honor, I filed an objection to that, and it's part of the court's record, and I know the court's going to read that. I heard that in the first case, that you're going to read everything. But, Your Honors, the rule to bring it up at the Court of Appeals level requires facts capable of ready determination, unrelated to the merits, and not genuinely disputed. In this instance, we've got an affidavit without opportunity for testimony, cross-examination, et cetera. It's easy to sign an affidavit. It's easy to go somewhere together. It's more difficult to withstand scrutiny under cross-examination and an attempt to look into what's really been going on in somebody's lives. And we don't think that's appropriate here. And I know the court has said they would make a decision on that today. But, Your Honors, the same Rule 60 motion could have been filed on remand.
On remand, did the trial court conduct another hearing on best interest, or did the trial court just put its order down?
Your Honors, the trial court first contacted Mr. Hamblin and I and said, let's schedule a hearing. Let's get this done. Let's get it done promptly. And then a short time thereafter, we received another letter indicating that he had reread the order from the Supreme Court, and he was not going to hold a hearing. He was just going to rewrite the order based upon the previous findings from trial.
Okay.
So there was no additional hearing and no opportunity to address what was going on in the people's lives. No opportunity to address whether, as Ms. McGee said, was the father making changes? Was he gonna do what was happening? So, and I'm sorry, I think I said Ms. McGee, Judge McGee. It's been a long night getting ready for this. That's the thing about Court of Appeal arguments, the rest of the trial calendar doesn't stop in the meantime.
I understand.
Yes.
I remember it well.
You have all been there at one point in time, I know. I have only 30 seconds left, so I don't really know that I have time to launch into another argument unless someone has a question.
You've still got your
I've
5
still
minutes.
got my 5 minutes, Your Honor. Thank you.
Morning.
Good morning.
I'm David Hamlin from the Obion County Bar, and I represent Mr. and Miss Bruner, who are sitting back in the back. This case has been decided by the Supreme Court as to the grounds for adoption. They have found that the father, Mr. Eves, failed to pay support and abandoned the child in that regard. And they sent this case back to the court just for the purpose of determining whether or not it's in the best interest of the child for this adoption to go forward. And so when you make that determination is made on the day of the trial, not what happened after, what happened 6, 8, 10 months before that, a year before that. In this case, the adoption was filed in September of 22. It was heard in February of 23. On that date, the court had to decide, was it in the best interest of this child to have Father Eves or Father Bruner? And I submit, is it in the child's best interest to have Father Eves, who had no home, who had never had a home of his own, or Father Bruner, who had a 3-bedroom brick home with another child, another sibling? Was it in the child's best interest to have Father Eves, who was using marijuana on a daily basis, hanging out with his friends, not being at home, or Father Bruner, who was at home, helped taking care of both this party's children? Was it in the child's best interest to have Father Eves, who had not involved himself enough to even take care of the child when the mother had to go to work? He was out with his friends, according to the testimony of the mother, on a daily basis. Was it in the child's best interest to have Father Eves, who had, at least by his own testimony, 6 jobs in this child's brief life? What, a couple of years? Was it in the child's best interest to have Father Eves, who had not even tried to rehabilitate himself during any part of this process whenever Mom was denying his visitation because he was using drugs? Did he go to AA, NA, counseling? No. The trial court found that he had attempted nothing, and that's one of the factors that the courts look at. Was it in the child's best interest to have Father Eves, who had threatened to kill himself, commit suicide, who had put a pillow over this child's mother's face and tried to smother her? Is that in the child's best interest to have that father, or Father Bruner, who testified that he loved this child dearly, who testified that they played games, watched Paw Patrol, the things that little bitty children do with their parents who love them? The issue that was raised by the Supreme Court and this court at our first hearing about this separation, these parties separated, And the Supreme Court used language that's not accurate in their opinion. They actually used the words that the Rule 60 motion, that they were separated and in the process of getting a divorce. No, there was never a divorce proceeding filed. The word was contemplating. There's nothing in the record that they filed for divorce. Nope, not in the process. And I don't know where the Supreme Court come up with that language, but that was totally inaccurate. Contemplating a divorce. I'm not even sure we need to be talking about that, because this issue came up when we were before the court earlier. And I'm not sure, I think it was Judge Armstrong, but anyway, the issue was brought up about, well, these parties separated. And the court, I think it was Judge Armstrong, stated this in his opinion, that we will not address that issue because that order was entered by the trial court and it was not one of the issues appealed to the Court of Appeals. And therefore, failure to raise that issue results in its waiver. So I'm not sure why we're even talking about it today, but I will talk about it.
We're talking about it today because the Supreme Court,
I'm sorry?
we're talking about it today because the Supreme Court sent it back.
Yeah, they said that's one of the reasons. But let's talk about contemplating a divorce. Is that grounds for setting aside the adoption, which is what the Rule 60 motion asked us to do? So on the day of the trial, there was no evidence presented that they were contemplating a divorce. The trial court ruled on that, found that there was no evidence that there were any disharmony, any thing going on that would cause these folks to be contemplating a divorce. They were happily married, seeking an adoption. But let's just say that on the day of the adoption, when are you supposed to determine someone contemplating a divorce subsequently? Do you have a time frame that says, well, if someone contemplates or separates after the adoption, one day we set it aside? Maybe you should wait a month. We'll set it aside if they are contemplating and separate. Or is it a year? No. It's the day of the trial. On that day, this trial court found that there was no evidence that these parties were contemplating anything about separation or divorce. That came several months later. So I submit that even though the Supreme Court said we need to look at it as one of those factors, on the day of the adoption, is there any evidence in the record to support the fact that these parties were contemplating a divorce? And I submit there is absolutely none. So I submit, Your Honors, that the best interest of this child is that the adoption be granted, that this child have, for a better way of putting it, Father Bruner rather than Father Eves. Any questions?
See none. Thank you.
Thank you.
Your Honors, I take a little bit of issue of determining it as Father Eves or Father Bruner. I don't know that our decision is today is who's the better father when you're considering, best interests of the child. I mean, we're still, the main issue was, termination of Mr. Eves' parental rights, and that seems to be a little bit different slant on it. And I think the Supreme Court noted that on their order of remand as well, that the two issues have to be separated, the adoption as opposed to the termination.
Yeah, but from the seat we're sitting in now, a ground has been found.
Yes.
when the ground has been found, you then look at it from the perspective of the child. What's in the child's best interest?
Correct, Your Honor.
So consequently, that's the seat we're sitting in today. And I don't want to waste all your time because I know you've got things to say, but I'm trying to, I guess, work through this analysis, the proper analysis of Mr. Hamlin's motion on post-judgment facts here. What we have is a determination by the trial court that no Rule 60 relief should be afforded you because there was no intent or there was no fraud,
Yes, Your Honor.
for lack of a better description here, that the parties did not mislead the court in any way.
Correct, Your Honor, and you asked me the last time we were here, and the reason I did not appeal that actual finding was because I didn't have any proof of it.
Right.
We gave it our shot at the hearing, we couldn't establish it, and I didn't have anything to appeal that decision on.
So I guess, doesn't that end the inquiry? Because you didn't appeal that, because there's no proof
Well,
of
Your Honor,
anything.
I don't think so. I didn't appeal the decision, but the facts are still in the record, and they were in the supplemental record, and they were, commented on and by this, of course, majority opinion, and then by the Supreme Court as well. So the facts were in the record. And although the court's decision wasn't challenged, both this court on the prior appeal and then the Supreme Court did not deny what was there in the record and admitted, because it affected the best interest analysis. I didn't mention this a while ago, when you add in the separation part and the instability factors that brings up, that adds in, that affects another 2 or 3 of the factors, so we're up to 15 of the 20 factors
But
affected.
what it also does is, shouldn't it allow Mr. Hamlin's client to respond to those factors that you assert are out there?
Are you saying then that they should be allowed to submit that affidavit? I'm sorry.
Let's say it like this, perhaps.
Okay.
There's no question there was a separation. I think both of you would stipulate that.
I think they did in the answer.
I assume, based on what Mr. Hamlin said, is he said there was never a divorce filed. Would you agree with that?
I have not seen any evidence of a divorce filed. I don't mind telling Your Honor that.
Okay, so does that not necessarily take care of what Mr. Hamlin's issue is?
No, Your Honor, I don't think so. Number one, the separation, this wasn't we got mad and we spent 2 weeks apart. According to the testimony in their answer, and they were separated in June of 23. They were still separated when we had the hearing in February of 24, so an 8-month period of time. That's fairly significant, and they only got back together after that hearing when we had that, and I filed that approach. We think that's a significant separation, and
Well, would you stipulate they're back together now?
Your Honor, I can't stipulate to
Okay.
that. I see them in the courtroom, but I don't have, I have a woman that called me last week that has not been living with her husband for 8 years, and she said, "I'm done. He's not coming back. I want a divorce."
Did you ask when she determined that?
Well, apparently it took 8 years, but I did, can I just say 2 more things? I am out
Sure.
of time here. Your Honor, that, I do think the age of the parties, at the time of trial, stepfather was 21, father was 22, mother was 23. When all this was going on, father was making these bad decisions at age 20 and 21. I asserted before, I think, in my brief, these parties are too young for a life-changing decision like this. And, Your Honor, I'm sorry.
Never mind. Go ahead.
Sorry, Judge. And then lastly, again, this isn't a case where father did nothing. Most of the termination cases that at least I've been involved in, one of the parents does nothing. In this instance, father tried, got hit with unfortunate circumstances, and obviously made the wrong decision at that point without aid of counsel. Thank you, Your Honors, I'm sorry.
No problem, no problem. Thank you, counsel. Appreciate your argument, appreciate your briefing. We will take this matter under advisement and attempt to get you an opinion at the earliest possible time. You may be dismissed, and we're going to take a recess until the call of the afternoon docket.